You can't just cherry pick the rulings you want to follow and ignore the ones you don't. That leads us down a very dangerous road. Despite what many on the right would tell you, we have never, ever traveled down before. President Trump and others in his administration now getting frighteningly close to testing the power of not just district courts, and there have been a number of examples of cases where they have defied district court rulings, but of the high court. Because now it sure seems like they are openly defying a Supreme Court order. And while many in this administration are claiming, no, that line, come on, hasn't been crossed. What other supporters of the president are doing is they're softening the ground for an argument that, it's not that big a deal if he does, because, other presidents have done this, which I will explain in a moment, is a bunch of BS. So, late last week, the Supreme Court orders in a 9-0 ruling that the government must facilitate the return of Kilmar Abrego Garcia from El Salvador. This is the guy deported from Maryland last month. In legal filings, the White House claimed the deportation of Garcia was an administrative error, but now they're portraying him as a violent gang member of MS-13. It seems that allegation stems from an informant 6 years ago, but as of now, there is no evidence that he's an MS-13 member. And here's something no one's talking about. During the first Trump administration, that's when Garcia was given an immigration protection called withholding of removal, which means the Department of Homeland Security, even in light of the informant's claims, officially did not consider him a danger to the security of the United States in 2019. So, now the lower court orders the government to facilitate and effectuate his release from El Salvador. The government appeals. They lost in the appellate court. Then the Supreme Court orders, quote, the order from a lower court properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. There is no ambiguity. They are saying the lower court had it right, and they must facilitate his release from custody, not give him a ride back if he's released. Facilitate his release from custody. The lower court properly determined. And they're saying that they have to start the process again. The only ambiguity is in how exactly to achieve that. The court went on, quote, the intended scope of the term effectuate in the district court's order is, however, unclear and may exceed the district court's authority. The district court should clarify its directive with due regard for the deference owed to the executive branch in the conduct of foreign affairs. For its part, the government should be prepared to share what it can concerning the steps it has taken and the prospects of further steps. Now, there's going to be a hearing today, but basically, the Supreme Court told the lower court, spell out what is it that you're ordering the White House to do. And it reminded them the executive branch controls foreign policy. But they made it clear the White House has to facilitate his release. And it is obvious the administration has made no effort whatsoever and doesn't intend to do so. Various administration officials twisted and contorted the court's ruling to try to justify ignoring it, including the Attorney General herself.
That's up to El Salvador if they want to return him. That's not up to us. The Supreme Court ruled, President, that if, as El Salvador wants to return him, this is international matters, foreign affairs. If they wanted to return him, we would facilitate it, meaning provide a plane.
That's not what the court said. I just read you what the court said. They didn't say anything about getting them a plane. They said that they were required to facilitate it and facilitate his release, not his ride. And by the way, the idea that the U.S. government couldn't get Garcia back by simply asking for him is absurd. We're paying for the prison space. El Salvador is a tiny Central American country, roughly the population of Missouri. They'd comply in 3 seconds if the U.S. made a serious request for the return of a prisoner. And President Trump really gave up the game when CNN's Caitlin Collins confronted him about the Supreme Court ruling yesterday.
Mr. President, you said that if the Supreme Court said someone needed to be returned, that you would abide by that. You said that on Air Force One just a few days ago. And they said that it must be facilitated.
Why don't you just say, isn't it wonderful that we're keeping criminals out of our country? Why can't you just say that? Why do you go over and over? And that's why nobody watches you anymore. You know, you have no credibility.
Legal issues, right? Due process. Dumb. Ignorant. Look, there have been signs that this kind of a showdown with the Supreme Court was coming. Back in February, Vice President J.D. Vance posted on X, quote, "If a judge tried to tell a general how to conduct a military operation, that would be illegal. If a judge tried to command the attorney general on how to use her discretion as a prosecutor, that's also illegal. Judges aren't allowed to control the executive's legitimate power." That's just not how the separation of powers works. And it's a fundamental misunderstanding that seems to be held by various top-level officials of this administration, including, by the way, Alina Habba, who serves as the interim U.S. attorney for the state of New Jersey. In a recent Fox News interview, Habba made a ridiculous claim that would have gotten her sort of laughed out of any high school civics class.
Our founding fathers created a document, the Constitution. There's a separation of powers for a reason. The executive branch is the ultimate authority on federal issues.
Oh, no. Article 3 of the Constitution makes it very clear the judicial branch has the authority to decide the constitutionality of federal laws, not the executive branch. But what's especially concerning is this idea that there's sort of testing in the right-leaning media, that it's not unprecedented for a president to defy a Supreme Court order. So I want to go through the various specious arguments that are being made in this regard. For starters, you're seeing some on the right point to a comment made by former President Biden during a speech last May, where he seemed to be saying he defied the Supreme Court after it ruled against him in a 2023 case about student debt.
Supreme Court blocked me from relieving student debt, but they didn't stop me. So far, I've relieved student debt for nearly 5 million Americans.
Now, Republican members of Congress and Fox News pundits, even Senator Tommy Tuberville, have run wild with that comment from Biden and held it up as proof that a president can and has, in fact, defied the courts.
Joe Biden said, I'm not going to listen to the Supreme Court when they said I can't do what I want to do with student loans.
Yes.
We even had the Supreme Court slapping down then President Biden's student loan forgiveness that the Supreme Court, the highest court in the land, said was unconstitutional. He went forward with it anyway.
Joe Biden didn't listen to the Supreme Court, by the way. You know, the forgiveness of student loans, they said you can't do it, and he turned around and continued to do it. So Democrats speak out of both sides of their mouth.
President Biden never defied a Supreme Court ruling. He actually complied with it fully. Case in question is Biden versus Nebraska. It was ruled on in June of 2023. And at issue was an executive action from the former president where he announced the cancellation of $10,000 in student debt for most borrowers. The mechanism he used to do it was something called the HEROES Act of 2002, which allows the Secretary of Education to, quote, waive or modify provisions of federal student loan law as the Secretary deems necessary in connection with a war or other military operation or national emergency. In this case, Biden used COVID as the national emergency to try to give him those powers. Now, I was very critical of the Biden administration at the time for trying to do this. And the Supreme Court struck that down in a 6-3 ruling, with Chief Justice Roberts writing in the majority opinion that President Biden was not trying to modify student loan law, but rather what he was trying to do constituted, quote, an exhaustive rewriting of the statute. So Biden didn't go and defy the court. He abandoned his use of the HEROES Act, just as the court had ordered him to do. And instead, he tried several more targeted methods to try and cancel debt in other ways. He expanded some existing programs which forgave loans for specific groups of people, like those who went into public service. That one was upheld by the courts. He also tried to create an income-driven repayment plan that didn't outright cancel the debt, but would have reduced it to almost nothing for many low-income borrowers. That one was struck down, so he pulls back on that one. The Supreme Court did not say President Biden couldn't try to reduce or cancel student debt. They said he couldn't cancel it using that one particular justification or method. So Biden abandoned that effort and tried others. He's allowed to do that. Trump has done that on many occasions. So while you can argue he could have chosen his words more carefully when he talked about not letting the Supreme Court stop him, he didn't defy a court order. The other name you've been hearing a lot from the right is Andrew Jackson. In March of 1832, the Supreme Court and Chief Justice John Marshall ruled that the Cherokee Nation had a right to their land and could not be forced to move by the state of Georgia. President Jackson supported Georgia's removal of the Cherokee people and decided not to help enforce the court's ruling, supposedly saying, quote, John Marshall has made his decision, now let him enforce it. So now many on the far right in particular, like Texas Congressman Chip Roy, during a recent interview on Fox News, saying that the Trump administration should follow in Jackson's footsteps.
I think he should take a page out of Andrew Jackson's playbook. At some point, J.D. Vance is right when J.D. said, hold on, you can't have a judge step in when the president is exercising his constitutional authority.
Putting aside that many scholars believe Jackson's comments are apocryphal, and he never actually even said that, let's assume he did. In that case, it was the state of Georgia which defied the ruling. They were the named party in the case, not the federal government. They were the ones who removed the Cherokee people from their land. They defied the ruling, knowing that President Jackson wouldn't stop them. But it was Georgia, not the president, who defied the court order. And here, J.D. Vance and others in the administration are talking about something different, openly defying a court order. That is very different from not trying to help enforce a ruling, as Andrew Jackson did. By the way, that doesn't make what Andrew Jackson did right. It just means the example doesn't work. The other example you've seen thrown around is Abraham Lincoln, connection with an 1861 order handed down by the Supreme Court, not by the court actually, just by Chief Justice Roger Taney. That's important. Federal troops had arrested a Maryland planter named John Merriman, suspicion that he was involved in a conspiracy as part of an armed secessionist group. Chief Justice Taney issued a writ of habeas corpus, basically the Chief Justice requiring an Army general to appear before the court and explain why Merriman was detained. Lincoln authorized military officers to suspend the writ in cases where they believed there were public safety concerns. So Merriman remained in prison, and they didn't do it. This was wartime. It was a civil war. And Congress later granted the president the power to suspend habeas corpus. Lincoln also defied a single Supreme Court justice, not a decision handed down by the whole court. But regardless, it's a completely different situation, a completely different circumstance. So when J.D. Vance or Alina Habba or anyone else in the Trump administration talks so openly about defying the courts, and they try to normalize it by saying, well, you know, other presidents have done it. Let's be clear. That's not true. What they are talking about is completely uncharted territory. What they are talking about is creating a constitutional crisis. And by the way, I don't use that phrase lightly. There are others who say, oh, we're already in a constitutional crisis. No. We're only in a constitutional crisis if the court's rulings are not enforced, particularly the high court. But I want to also be clear about something. The left has not been an innocent bystander in all of this. They have helped pave the way for this kind of assault on the judicial branch by attacking the credibility of the Supreme Court for years, railing against a court that they say was overly politicized, calling it illegitimate, all because of rulings they didn't like. Congressional Democrats like Senator Richard Blumenthal, former Congressman Jamal Bowman, Congresswoman Alexandria Ocasio-Cortez are just a few of the examples. Listen.
Judges ought to be angry about this crisis of legitimacy that is enveloping the Supreme Court because it affects our entire judiciary.
The Supreme Court is illegitimate. It is corrupt. It needs reform, expansion.
They themselves have been destroying the legitimacy of the court, which is profoundly dangerous for our entire democracy.
And now they want everyone to abide by the court's rulings. I warned the left that the court would be a guardrail against excesses in a Trump administration. But they wanted to appeal to their base, and their rhetoric over the past few years has undermined public faith in the courts. The latest poll from the Annenberg Public Policy Center, which conducts an authoritative poll every year gauging trust in Supreme Court, showing a low 56% of Americans trust the Supreme Court. Now, only a little or not at all. So that means the majority. Only a little or not at all. It's Democrats that help bring us to a place where the public doesn't trust the court. And so now you have top members of the administration talking openly and brazenly about defying court orders. The good news is that there's a recent poll out from Marquette University that says that 83% of Americans generally believe the president, quote, must follow decisions from the Supreme Court. I'm so curious about those other 17%. You can't just cherry pick the rulings you want to follow and ignore the ones you don't. That leads us down a very dangerous road. It is a road that, despite what many on the right would tell you, we have never, ever traveled down before.